Good afternoon. Welcome to today's webinar, Employment Law Developments While You Were Quarantining. I'm Miriam Rosen, the Chair of McDonald Hopkins Labor and Employment Practice. I'm pleased to have joining me today Karina Conley, an attorney, labor and employment attorney in our Cleveland office. Before we jump into our presentation, let me take care of a few logistical issues. Karina and I are happy to answer questions at the end of this session. You can submit your questions anytime during the webinar by emailing events@mcdonaldhopkins.com or entering them in the question pane. If you submitted a question in advance of today's program, we'll try to cover those during the presentation. Let me add that we do have a lot of material, and if we aren't able to get to your questions within the hour that we've allotted, we'll spend a little extra time at the end, and then we'll follow up individually if we need to. And one other note that I think is a constant, I want to apologize in advance if we have any technical issues. And with that, I think we're ready to get started with the program. So let me take you back to the beginning of 2020. To quote a popular meme, let's see how it started. We actually have a reference point for that. In January, we presented a business hour covering 20 employment law issues for 2020. We identified four overarching areas that you see here on the slide. Political tension, and I should add dissension. This year in particular, political tensions have played a role in the climate of the workplace, certainly, and how employment law is developed. Social and cultural change, which always impacts the workplace and employment. And this year, in particular, because a lot wasn't getting done at the federal level, we saw state law developments that were also impacted by those social changes. And finally, we anticipated that technology would have an impact, a broad overlay on the workplace. That reflects what we thought the challenges would be that employers would face in 2020. Now, I think you know how this played out. As it turned out, the one overarching employment law challenge in 2020 was dealing with COVID-19. It touched on almost every aspect of employment law, from accommodations to wage hour issues. But it also turns out that while we were quarantining and laser focused on the crisis, there were many non-COVID-19 employment law developments that were actually happening. And in many ways, those were some of the things that we actually predicted in January of 2020. And it's those non-COVID-19 developments that we want to focus on today. So we'll be talking about developments at the EEOC, including noteworthy cases and settlements, some fiscal year-end activity, and a surprising amount of guidance issued by the EEOC during 2020. Developments at the U.S. Department of Labor, including new regulations, new guidance, and new forms, and then a host of trending topics, much of that driven by state legislation, but also by social issues and political change. So we'll move right into some of those areas. So one of the ways that we can identify kind of what the level of EEOC activity has been is to look at the year-end results. And what we see is that the EEOC announced at the end of their fiscal year, which is September 30th of 2020, record recoveries. It's surprising in this year when there was certainly a slowdown in at least the early spring. So record recoveries for victims of discrimination in the workplace. Much of that was about 60%, that 333 million number represents 60%, was secured through settlements, mediation, and conciliations. In fact, half of that amount just through mediations, a program that the EEOC believes is particularly important. Now, in February of 2020, some of this might be attributable to a policy shift announced by the EEOC chair in February of 2020. Janet Dillon indicated that while the EEOC was going to continue to focus on vulnerable employees, the EEOC would also prioritize robust compliance assistance from employers. In fact, Dillon noted that litigation is truly a last resort. Now, obviously, those are welcome words for employers. Now, let's see how that played out on the next slide. Another way that we like to understand what happened at the EEOC was looking at the litigation they filed at the end of the year and throughout the course of the year. In 2020, the EEOC filed 94 merit lawsuits and 7 subpoena enforcement actions. You can see that this is down significantly from previous years, perhaps because of the policy shift announced by the EEOC chair. Perhaps we can attribute it to the pandemic. I don't know that we'll ever really know what prompted that. But this chart gives us an indication of what types of lawsuits the EEOC filed, and that's important too because it really shows us their priorities. You can see that the biggest number is 60 lawsuits based on Title VII. When we say Title VII, we mean sex, race, national origin, and religion. 41 of those 60 were based on sex or sexual harassment. Now, that's not surprising as we continue to see kind of the ongoing effects of the Me Too movement. Translating that for you employers into some practical advice, what that means is we need to continue focusing on harassment training. This is still an area that the EEOC is focusing on. They're willing to file lawsuits over it. If I know we have a number of employers on the line from Illinois. If you're an Illinois employer, there are new requirements in place this year for mandatory harassment training. So you have just about 2 weeks to get that in. What will be interesting, I think, is to see, how this plays out in coming years in terms of harassment. If we have fewer employees in the workplace, will that affect the harassment numbers? The other significant lawsuits were based on the Americans with Disabilities Act. And again, I would say it's not surprising. It's a key focus of the EEOC. It's also an area where employers struggle to match their expectations for productivity with employees' need for assistance. Now, on the next slide, Karina is going to talk through some of the ADA issues that the EEOC focused on in 2020.
Yeah, thanks, Miriam. So in line with what Miriam said, overall, although cases were down, EEOC cases were down, we have seen certain trends that she noted and themes that are actually in line with some guidance that was issued and that we're going to discuss a little bit later here in the presentation. The first area we have seen the EEOC take action more significantly, and as Miriam mentioned, is with regard to the ADA, but in particular with issues related to employee drug use and medical treatment. In the first 2 cases here, the EEOC filed suit against employers who either revoked an offer or terminated an employee for disclosing prescription medicine use in order to treat addiction. In particular, in these 2 cases, opioid addiction. In the first case, the HR department conducted their own research regarding potential safety-related side effects of the medicine that the employee was taken, but they actually failed to engage, according to the EEOC, in any interactive process with the employee to determine whether or not that treatment actually affected the employee. Similarly, we saw the EEOC file suit in Alabama against an employer who refused to hire an applicant after the applicant disclosed during a pre-employment drug screen that she used anti-anxiety medication. They revoked the offer, and the EEOC said that they failed without engaging in the interactive process. And the final ADA issue that we've seen here that the EEOC has kind of, always kind of nipped employers, they show that even the best intentions can violate the ADA sometimes. So in the final lawsuit in California, the EEOC filed suit against a car dealership and its management company who filed a title clerk who left work for a sudden illness, underwent testing for cancer, and was ultimately terminated. The key being that in the employee's termination letter, the employer said specifically that the termination was not performance related, but that the employee should take time to focus on her health. So seemingly a good deed, but they didn't engage in an interactive process, which the EEOC alleged violates the ADA. The next area that we have seen the EEOC take on more frequently is post-termination retaliation, and in particular, in this case, filed in Idaho, the EEOC filed suit against a recruiting services company after the recruiting services company fired the employee purportedly for filing a charge of discrimination. But the employer allegedly didn't stop there. The employer allegedly then gave a negative reference to a prospective new employer of the former employee, and then actually sued the former employee for violating the employment agreement between the former employee and the company. The third area that we've kind of seen, and something that I think we'll see more of, particularly as we see employers implement more social justice and cultural initiatives, are cases related to employees' purported exceptions to that, and in particular religious exceptions. I think we'll certainly see that, and we'll talk a little bit about it, I'm sure, with regard to vaccinations regarding COVID-19. But as you recall, we're trying to cover some different things here today. In this case, the EEOC filed a lawsuit against the Kroger company in September, alleging that the Kroger company was inflexible in its response to two employees who voiced religious objections to wearing a rainbow heart emblem on their apron, which was a part of the Kroger company's new dress code. The employees both expressed that their objections were based on religion and offered alternatives. One offered to wear a different apron, and the other one offered to cover up the rainbow emblem. But the Kroger company, as I mentioned, the EEOC is alleging that the Kroger company was inflexible in their response and ultimately just disciplined and terminated the employee. And some other places you can see trends and topic shifting in the EEOC are in their settlements. So, Miriam, what have you seen at the settlement level?
Yeah, that's a good question. The settlements were so large that I think it's worth taking a look at some of those to understand what they might mean and how you could translate them into your own workplaces and hopefully avoid some of these issues. So the first settlement we have is Walmart settled a case with the EEOC for $20 million. When this hit, you kind of take notice of that, even if it's Walmart. And the case involved pre-employment physical testing. So Walmart required applicants to successfully complete a physical agility test when applying for order filler roles in the grocery, something that's a big issue right now. The EEOC claimed that the test disproportionately excluded female applicants. I think the important takeaway on this case is that this was a neutral policy. This policy wasn't applied to just women or just men. It was a neutral policy, but the policy inadvertently had, or the EEOC alleged, had an impact on excluding women from opportunities. So what's the takeaway from that for employers? Really carefully examine the criteria that you're establishing for roles and take a look to see whether those performance criteria are necessary, especially if you're talking about either degrees or physical requirements. Now, another interesting case is with a smaller employer, a nonprofit healthcare system in mid-Michigan. And this is a case that involved the Equal Pay Act. We don't see Equal Pay Act claims too often, and Title VII, and that would have been a sexual discrimination claim, that a female business developer was paid less than two male peers for the same work. This case was settled at $104,000, but it also required the employer to do some other things. So this employee was still employed with the employer, which is always a difficult situation, and they were required to increase her pay, revise their compensation policies to ensure compliance with the EPA and Title VII, train managers on compensation discrimination, and post notices to inform employees of their rights. Now, among these other large cases, why did we decide to include this case? I think that We are going to see a lot more equal pay and pay disparity cases in a new administration. I think it's worth noting and taking a look at your pay practices. Lots of times when we're talking with employers about pay practices, it's easy to come up with justifications about why people are paid different rates. But I think you have to break some of that down and really look at, are they doing the same job, and what are the justifications for paying employees differently? If we're together discussing these issues in December of 2021, I think that we will see that equal pay claims will be a big issue for the EEOC under the new administration. And finally, we have the Dillard's case. The company, in this case, resolved a claim alleging that Black employees were denied promotions based on race. The company paid $900,000 to settle those claims. I think what's interesting about this case is some of the other requirements other than just the dollar amount. Employers can look to the settlement to understand some things that they can do proactively to avoid these types of claims. So the EEOC, in settling this case with Dillard's, required the company to develop and post written promotion policies. So how do you make promotions available to all employees? That's really what they're getting at. Post supervisor and manager vacancies, getting at the same issue, provide anti-discrimination training, and use broad recruiting sources. And we know that going to different recruiting sources, not just word of mouth, for example, or your normal recruiters, is a good way to find diverse candidates. So as part of the settlement in this case, the company was required to reach out to historically Black colleges and universities to recruit Black candidates. So these are interesting settlements, and almost as interesting as the amounts, I think, are the other requirements related to the aspects of the settlement. Now, we had a big development at the Supreme Court in 2020. And we're not just talking about a change in personnel here. While we were quarantining, the Supreme Court issued a significant decision in an employment case, and that's the case of Bostic versus Clinton County, Georgia. By way of a little brief background, this case was a consolidation of 3 lower court appeals cases. 2 of the lower court cases involved terminations of employees for being gay, and the 3rd case involved a funeral home that hired a male employee who later informed the employer that he planned to live and work as a woman. So this was a transgender case. The Supreme Court's decision in June resolved the issue of whether Title VII protects an employee from discrimination based on the employee's sexual orientation and gender identity. You can see some of the strongly worded opinion by Justice Gorsuch, who was a surprising choice to write the opinion, and not to read the whole thing, but what the case made clear is that an employer who fires an individual merely for being gay or transgender defies the law. I think that clarifies for us that sexual orientation and gender identity are within the scope of Title VII. So, what are our takeaways from this? Employers who haven't already done so should make sure that their policies reflect that decision. Many states already include this in their state fair employment laws. And, I think Karina and I would both tell you that we see many, many employee handbooks that already address this. In addition, since this is a change, I think it makes sense to incorporate it within your training for managers and employees. And I think, again, when we talk about this in the future, we will see changing trends with EEOC charges and lawsuits that reflect this decision. Now, the EEOC wasn't just busy with settlements and lawsuits. Karina, what issues did the EEOC address through guidance and rulemaking this year?
Yeah, so as I previously mentioned, we've seen the EEOC issue some guidance over the last couple of months, basically starting in August, that we think will hit at potential enforcement themes going forward. The first area of guidance was entitled The Use of Codeine, Oxycodone, and Other Opioid Information for Employees, which goes in line with the 2 cases that I mentioned at the beginning of the presentation. In this guidance, the EEOC affirmed that illegal drug use is not a covered disability in and of itself, but employees are protected in 3 instances: when they're lawfully using opioid medication with a prescription, when the employee is in treatment for opioid addiction with medication-assisted treatment, or if the employee is recovered from addiction and is seeking a reasonable accommodation in the form of time off for meetings, an altered schedule to attend support groups, and things like that. Obviously, this is in response to a lot of activity with the opioid crisis that has happened over the last few years, and in response to lawsuits that have come out. The key takeaway, and to avoid the issues in the cases that I previously mentioned, is that employers should really give anyone subject to drug testing an opportunity to provide information about the drug use, which could be potentially lawful or a reason for a positive result. Again, the default always being fall back on your interactive process, have a conversation with the employee. Now, in this guidance, the EEOC also advice for healthcare providers, informing them generally of patients' legal rights in the workplace, including privacy, and providing guidance for healthcare providers in providing documentation in covered disabilities. The second area that we saw, which is not surprising in the slightest, that the EEOC came out with some guidance on, and what we'll call guidance, in September 2020, was actually a Q&A document that it released regarding telecommuting. And obviously, that's a really hot button topic and issue, and something we see a lot of in response to the ebbs and flows of the surges of the coronavirus, as employers are letting employees work remotely, bringing them back, letting them work remotely again, and bringing them back. So what did the EEOC say here? The EEOC emphasized that employers do not have to automatically grant employees requests for telework. The employee must still have a disability-related limitation impacting their ability to perform their job in the workplace. And another key takeaway, employers aren't required to grant an employee's preferred accommodation. You can provide an alternative if it addresses an employee's limitation. For example, I've had some clients call. The employee has said that they would like to continue working from home. It's their preference. Again, we recommend going through the interactive process, and something that I've recommended, in particular, this employee didn't want to be in the office physically with a large group of other employees above 10, because that's the CDC recommendation and most states' recommendations of social gatherings. So the employee was objecting to coming to the office with more than 10 people. Obviously, again, we suggest going through the interactive process, but also this employer really needed this employee. They needed to be in person for some training and some other activities. So something that is advisable is have a discussion with the employee. Okay, well, if you don't want to be there during normal working hours with 10, can we stagger schedules? Can we bring people in at different times? It doesn't have to be the employee's necessarily preferred accommodation. It just has to be reasonable and something that's not an undue hardship on the employer. And along the same lines, the fact that employers have allowed people to work from home temporarily during a pandemic does not mean the change is permanent and that it doesn't create an undue hardship on the employer. The EEOC also in this guidance recommended, as we typically do, a case-by-case analysis, and also re-emphasize that it's 100% okay to continue to temperature and symptom check and prohibit employees from entering the workplace if the employee refuses to answer screening questions or have their temperature taken. I think we'll see some more of those issues going forward. In fact, I think we'll see a lot of them going forward after the vaccine rollout and people start coming back into more congregate work settings. The third area of guidance.
Karina, before you move on to the next area, let me I think Karina is absolutely right on that I think when we see employers who are ready to bring employees back, there will be many employees who still want to stay at home. And one thing that might help you is to make sure you have a strong job description that indicates the reasons that you need employees in the office. And I think a lot of employers have learned, while there are jobs that can be done at home when you're forced to, there are things that happen in the office that can't happen at home. So think about those and think about how you might revise your job descriptions to help you.
So absolutely. 100% agree. And that way you have something you can provide to the employee when you're having that discussion with them. The third area, and something that we mentioned, was a proposed compliance manual update regarding religious discrimination. Nothing earth-shattering here, really. The EEOC in November essentially just affirmed that that religion is broadly defined and employees are protected under Title VII if they have beliefs or practices that are truly sincerely held. What's key here, though, and something that I've jumped around a little bit, is with regard to social, political, or personal preferences. The EEOC specifically noted that those are not religious beliefs for purposes of Title VII. For example, if somebody doesn't want to take the vaccine because they feel that it harms their body, but they don't have an underlying sincerely held religious belief in support of that objection, it's unlikely that an employer would have to make that accommodation, and they could still require the employee to take the vaccine. And then the third area that they focused on was just the re-emphasization that religious institutions are exempt from Title VII discrimination suits, and it's in line with there was a partner case with Bostic that expanded the ministerial exception, and holding that discrimination laws in Title VII is not applicable to employees whose work is vital to a religious institution. So in that case in particular, it was a teacher at I think it was a Catholic high school. The final area, and this is more, again, just an affirmation and confirmation of something the EEOC was already doing. The EEOC in October issued some guidance regarding procedural changes. The EEOC, obviously, I think in response to the remote work and COVID, confirmed that digital submission for charge-related documents is appropriate, and something that most of us have been doing for a very long time. It did, however, modify the language in notice of dismissal order correspondence slightly to more clearly communicate to charging parties and respondents the importance of the EEO's decision to close the investigation and to have greater efficiency in charge closure. The EEOC, though, was not the only agency busy while we were quarantining. In fact, the DOL was quite busy, was it not, Miriam?
Yeah, that's right. The DOL was very busy cranking out COVID and non-COVID related regulations, guidance, and opinion letters. And we could spend not just an hour, but hours on, obviously, the Families First Coronavirus Response Act guidance that the Department of Labor provided. Frankly, it is kind of astonishing to get a new law and have guidance issued so quickly, along with frequently asked questions and fact sheets and other updates. And they've done I would say the DOL has done a good job of presenting that in a way that employers can digest. But they were also doing lots of other things. I think much of the DOL's activity can really be viewed as, I would say, a culmination of the Trump administration's agenda to reform key parts of federal labor law and really move it in a different direction that we had seen during the Obama administration. And it took almost that full 4 years to get to that point, and we saw a lot of that, I would say, come to fruition. You can see on this chart. We've just picked out some highlights because we could have filled this chart up with all the different things that were going on with the Department of Labor agencies, which include the Wage Hour Division, the OFCCP, and the NLRB. Frankly, I think that some of these reforms might have been highlights of a campaign if it hadn't been, overtaken by other things that were occurring. The highlights that we've put here are important reminders of what you need to be thinking about. So let me mention a couple of those. In January, the DOL issued some guidance that was intended to bring clarity clarity, at least from their perspective, on employer and employee relationships. So we saw a new joint employer rule issued in January, kind of narrowing the circumstances when two employers who both have control over an employee can be considered joint employers. The NLRB issued similar guidance in February, and the joint employer rule actually became effective in March. I'm not sure anybody was paying attention to that in March. But no worries, don't get too committed, because in September, a New York federal court struck down the key parts of that rule, and I don't see that coming back anytime soon. Let's look at some things that did stick, though, that are important, frankly, in many ways, more important for your everyday kind of employment law administration. So in July, we saw new FMLA forms and notices. Forms don't make any really substantive changes, but they're intended to, in some ways, make them easier to use. I think, as an employer, you're going to need to look at those forms and really think through whether they are easier and whether they give you the information that you need to administer the FMLA. So the FMLA forms issued by the Department of Labor are templates, and so you can use the new forms. You could continue to use the old forms, or you could, in fact, create your own forms as long as those forms are consistent with the FMLA regulations. You can find the forms on the DOL, the template forms on the DOL's website. Another interesting development was that the DOL announced that it would change its position on liquidated damages. So during the Obama administration, the DOL had started to require that any time an employer had an FLSA audit and resolved it, they were required to pay liquidated damages, meaning double the damages if there were any findings of failure to pay overtime or other wages. So this was really, this could sometimes impact employers who had never had a FLSA violation, really seen as a hardship. And finally, after 4 years, the DOL has backed off on that. Now, with the new administration, we may see a change back to that old position. And really, when you think about it, that reflects kind of a different philosophy from enforcement to compliance. We see that throughout the federal agencies, and it was really starting to take hold this year. Let's see, what else we have here? Oh, the DOL issued a number of opinion letters, and opinion letters are when employees send in questions to the DOL. Basically, employers send in questions and ask for guidance, and so the DOL issued opinion letters on travel time, on training time issues. We probably saw more opinion letters this year than we have seen in many years. Now, again, during the Obama administration, they stopped issuing opinion letters and just started issuing administrative opinions on issues that the Wage Hour Division was interested in communicating. So it'll be interesting to see in a new administration if we continue to have those opinion letters issued, which are really helpful to employers in understanding and applying some of the trickier areas of the Fair Labor Standards Act. These are some of the developments that we saw at the state law level as well. So we saw developments in terms of paid family and medical leave, marijuana legalization, hairstyle discrimination, workplace privacy, and some recent COVID-19 immunity laws. And we'll look at a few other trending topics as well. The first one, the paid family and medical leave, is an interesting issue because we'd already seen significant movement in that area, with 9 states and the District of Columbia having paid family and medical leave laws, and 14 states having paid sick time laws, as well as a number of cities, many of those in California. During the pandemic, we saw several states implement their own emergency paid leave laws, Colorado and New York. Some of that to cover employers who didn't fall within the scope of the Families First Act. But what's interesting to reflect on is that perhaps the Families First Act may be a model for a federal paid Family Leave Act, providing some paid sick time as well as paid time off for child care. What we know is that there's actually bipartisan support for paid family leave at the federal level. About 18 months to 2 years ago, federal workers were given paid family leave of 12 weeks. And we know that there have been a number of bills introduced on both sides of the aisle for it. So I think one of the things we could see early on in a Biden administration is a bipartisan bill providing for paid family leave. Karina, can you tell us about some of the other state legislative developments?
Yeah, of course. So something that we've seen grow over the years and that we've talked about, I think, in all of our presentations that Miriam and I have done together recently, is the expansion of marijuana legalization. In fact, last week, the House passed the MORE Act, which would remove marijuana from the Controlled Substances Act as illegal and expunge previous marijuana-related convictions. It would also create an office of cannabis justice within the DOJ. This would reconcile, obviously, contradictions between state laws that currently in certain states allow for recreational and or medical marijuana and the federal government's prohibition and criminalization of it currently. But let's not get too ahead of ourselves. It's very unlikely to pass in the current Senate, but let's all keep our eyes on Georgia to see if there's any changes that happen that might push this through. There were also some state ballot initiatives in addition to the federal initiative that was passed last week. 5 states on their ballots, Arizona, New Jersey, South Dakota, Montana, and Mississippi, all approved measures to legalize recreational use of marijuana in some form or fashion. In some, that brings the total of states with recreational marijuana legalized to 15. 2 territories also have legalized use of recreational marijuana, and DC. Ohio Senate Bill 3 and House Bill 1 were also introduced earlier this year, and although they don't legalize recreational use of marijuana, they do attempt to reform drug sentencing laws and expand alternatives for jail and prison sentences related to marijuana crimes. So it'll be interesting to see with recent social justice initiatives and other issues if that has any steam either. Another area we've seen gain steam, and it's not necessarily new either, but the House also passed the Crown Act, and it is a federal initiative to ban discrimination based on hairstyles commonly associated with a particular race or national origin. It's gaining a lot of momentum and has over the last couple of years. In fact, the EEOC has long taken the position that grooming policies that disproportionately impact certain races violate Title VII. 7 states have also passed similar acts, and there's an increasing number of cities and localities that have also passed recent acts or made changes, and employers have also made changes to their policies, which is something we recommend many of our clients take a look at and review. So for example, if you take a look at this timeline, in March, Ohio House Bill 535 was introduced, banning discriminatory policies in Ohio. Schools that penalize students, especially students of color, for wearing natural hairstyles that embrace their cultural identities. It's in line with, I think, a news story that went viral and was all over a wrestler who was forced to cut his dreadlocks off before his match. In June, Reynoldsburg, Ohio, banned discrimination based on hair texture specifically and LGBTQ status. In October, the city of Pittsburgh and Allegheny County, PA, and even Covington, Kentucky specifically followed suit. And in November, the UPS announced that it modified its strict appearance guidelines and lifted its ban on certain facial hair, beards, and natural black hairstyles. We would be remiss without mentioning in this next slide the initiatives that have been passed regarding COVID-19 immunity and exceptions for employers. In fact, it's actually quite an area of debate and a subject of consternation in the current talks between Republicans and Democrats at the federal level regarding the stimulus package. So in the meantime, while they have been sorting that out, some states have taken action. In particular, Michigan has House Bill 6030, and it provides employers with immunity from liability for any COVID-19 claim brought by an employee for exposure to the virus while at work, as long as the employer acted in compliance with all federal, state, and local statutes, rules, regulations, executive orders, and agency orders related to COVID-19. So obviously in Michigan and our Michigan employers, we highly recommend staying abreast of all of those, following them closely, and implementing policies and procedures in line with them. Ohio passed a similar law, House Bill 606, and it grants employers immunity. And in Ohio, it's broader than employers too. It's actually hospitals, other institutions, colleges, and universities from claims asserting that an injury, death, or loss to a person or property was caused by exposure or transmission of COVID-19, so long as the employer's conduct was not, or the institution's conduct was not reckless, intentional, willful, or wanton. I think that there will probably be some further litigation about the definitions of those and what constitutes reckless, unintentional obviously, but willful or wanton misconduct with regard to COVID-19 protections and following of certain procedures and policies. But I think we'll see that come down the pike. Georgia, Louisiana, North Carolina, Oklahoma, Utah, and Wyoming have all enacted similar laws. And like I said, it's a sticking point right now at the federal level with negotiations between the two parties. One thing we want to be aware, that employers want to be aware of or be cautious of, however, and something that I think might also gain traction in other states, particularly blue-leaning states, is Michigan House Bill 6032. Specifically in that bill, employers are prohibited from disciplining or discharging employees who do not report to work because of principal symptoms of COVID-19 or seeking a diagnosis. So what are the best practices? As always, we suggest following federal and state agency guidance, keep up on the regulations, the rules, be transparent with your employees, and provide frequent reminders and communication. With everybody working at home, there's been a lot of employee privacy workplace issues that have arose recently. We've gotten a lot of questions about that. Miriam, what have you seen in your neck of the woods?
Yeah, so privacy issues are nothing new, and certainly with the changes in technology, these were issues that were kind of percolating, and you can see that, we have a state that is viewed as really one of the most aggressive states, California, implementing the California Consumer Privacy Act that took effect in January, although they did kind of put some things on hold due to the pandemic. But I would say we see kind of a new sense of urgency in protecting information because of the enhanced ability and need for employers to protect, seek medical information, and also, frankly, because in a lot of ways your employers are in your homes now, right? They're seeing things they never saw. So that's all kind of contributing to a sense that we need to do more to protect employees' personal information. You're going to be surprised when you hear this, because I was shocked to find out that in 2020, there were 30 states that introduced legislation related to consumer data privacy protection. Some of that covers employment, some of it doesn't, but that's a lot of states addressing these privacy issues. Now, you won't be surprised to hear this, that almost none of that passed because state legislatures were focused on other things, and it certainly wasn't a priority. But it's something to think about going forward, and it's certainly something to heed as you're thinking about the information that you're collecting and what you do with that information that you collect. Even at the federal level, in May and June, there were 2 data privacy bills introduced. And this is another area I would say to watch related to a bipartisan initiative to protect employee data privacy. Do we think that at the federal level it will go as far as the California Consumer Privacy Act? Absolutely not. But is there likely to be something And will that impact employers? Yes. So I think that we can't talk about 2020 without talking about how the social justice movement impacted the workplace. It, in many ways, prompted an open dialogue for the first time in workplaces, which was welcome. But in some cases, it led to increased dissension. Contributing to that, I would say, in a big way, was the use of social media that lots of times fanned the flames. So Karina and I both dealt with numerous situations where employees had posted inappropriate content on social media that felt threatening to one side or another, and left employers saying, how do we deal with this? Especially when that conduct impacts the workplace. It might happen outside of work, but now people are friends on Facebook and they see it and they want action. And so in those situations, lots of times we're going to go back to basics and we're going to say, what laws address this situation and what do our policies say? So surprisingly, employers have fallen back to things like dress code policies and codes of conduct to say you can't, that type of conduct is unacceptable in our workplace. Some things to think about, though, are the National Labor Relations Act, which does protect certain types of concerted activities by employees related to terms and conditions of employment. And by concerted activity, we mean employees who are either acting on behalf of a group or a group of employees. Now, that wouldn't protect an employee who is just engaging in individual inappropriate conduct. It's always good to check on that to make sure that you've evaluated appropriately. And then some state laws may protect political expression or legal off-duty conduct. One thing I'll say that we've noticed is a lot of employees are quick to say, hey, I have freedom of speech. And remember, that applies to public employers and not private employers. I know that lots of employers have questions about how they can address these situations. And I think if you're establishing a foundation and expectations for civility, that goes a long way. And I think not overreacting also goes a long way. The other thing that we saw in response to these social issues is employers making commitments to do certain things, issuing statements and making promises related to diversity, equity, inclusion, and social justice. What I would say is now that we've moved beyond those tense times, at least maybe for the moment, it's important to make sure you're following through on those commitments. It's important for your employees' morale who relied on what you said. It's also important for your credibility as an employer to be able to go back and say, when we said we would do something, we meant it. So I think that we also can't ignore that 2020 has taught us a lot about the future of work. We know now that work can be done in different ways, and we really have to, I think employers have to examine those issues pretty deeply. Remote work's here to stay. Certainly not for everyone every day. We know there are things that just, for many employers, can't be accomplished outside of the office. We also know that creating a workplace culture sometimes means bringing people together to collaborate. So what I would say is you're thinking about the future of work, and I know that almost every employer we talk to is, it involves some hard work from employees, from managers, thinking about how you get things done. Because I think some of those issues and concerns that employers had, will employees be efficient? Will they actually be working? Maybe we've gotten over some of that. And we really need to focus now on how we set expectations and hold employees accountable when they're at home. We also need to think about some of those employment law implications. Who gets selected for remote work? How do we judge performance? And how do we ensure that, first of all, we're paying employees appropriately when work can spill over into many different hours? And how do we make sure we're rewarding employees appropriately if they're not there in front of us and we can't necessarily see what they're doing? As I mentioned, workplace culture, that potentially could take the biggest hit in a remote work situations. And so I think it's incumbent upon employers to think through how you find ways to connect employees, those employees who may have just been sitting together talking about something and come up with an idea that doesn't happen naturally anymore. How do we foster relationships? I think those are some of the biggest things that employees are missing, and employers are not reaping the benefits of those collaborations. So this will definitely be an issue that employers will be thinking about in 2021 and beyond. And obviously, we'll also be thinking about what the Biden administration may have in store for us. And some of those issues include a focus on health and safety. Now, we know that President-elect Biden has committed to addressing the coronavirus, and in some ways, the one of the agencies from the Department of Labor that has been called out as not being aggressive or maybe busy enough is OSHA. And so what we're hearing is that we may see some additional OSHA guidance, and I think we'll still see fallout related to workplace safety issues, even as a vaccine is rolled out and as employees get back to work. We know that the Biden administration is really committed to advancing employee rights, and kind of tied to that is a shift from compliance, which we have seen during the Trump administration, to enforcement. Issues of the new workplace. I do think that the Department of Labor, the EEOC under a Biden administration will focus on issues of privacy, remote work, and certainly gig workers and how they're treated as employees, as independent contractors. And we will return to, I'd say, a strong pro-labor agenda where there is strong support for union organizing and collective bargaining. So it is, in many ways, going back to what we saw under the Obama administration. We'll see how far back we go and what that means for employers. I'm going to turn to our last slide and really look at what we've seen in 2020, and we're ready to say goodbye to COVID, and how will it go in 2021? One of the issues that we didn't address that we know is a pressing issue for employers is tension over vaccine requirements. So even though that's not really a development, that a non-COVID development, we'd like to address it because we know that it's on everyone's mind. So many employers have asked us, can we mandate vaccines? And we know from the EEOC guidance that employers can require vaccines if it's job-related and consistent with business necessity. If you need it to operate your business. Now, where there's some exceptions relate to employees who say that they can't take a vaccine due to a disability, so ADA issues, and also who might have religious exemptions. And like other situations involving the ADA or a religious accommodation, you have to go through the interactive process of evaluating, are there other things we can do, or is there a reason that we can't accommodate an employee and can require this vaccine? Now, here's one other thing I'll add. Because this is such a hot issue and really a more extreme situation than we've seen with other vaccines, I think that we will see some guidance from the EEOC and maybe other organizations, the CDC, OSHA, helping employers understand when they can mandate vaccines, under what circumstances. And that guidance may be different depending on the nature of the employer. So certainly a healthcare employer may have, even now with flu vaccines, we know that healthcare employers have more latitude to require vaccines than other employers. So I think that will be an evolving issue. Certainly, we'll be looking at modified return to workplaces and issues related to that, issues of the new administration. Again, state law developments. The states are chomping at the bit to address some of their issues that they put on the back burner. So we will continue to see state law developments. And I think a lot of the social issues that we have seen this year will continue to impact employment law and workplaces. So we have a couple questions here, and we have just a few minutes to take them. So one of the first questions we have is a question regarding travel vacation policies for employees that travel out of state. During COVID, what policies is an employer allowed to implement mandatory testing before an employee can return to work? Do you have thoughts on that, Karina?
Sure, yeah. So similar to the vaccine, the EEOC has issued a little bit of guidance on this, and does allow employees to require employee testing as they re-enter the workplace, so long as we mentioned, it's related to a business necessity. For example, if the employees are working in a more congregate setting, such as a manufacturer or something along those lines. Again, the employer should take into account any exceptions that the employee presents to them, whether they be religious or ADA related to testing, to COVID-19 testing after traveling. But certainly, I think generally, yes, you can, so long as that it's job related and consistent with business necessity.
Yeah, absolutely. Yes, absolutely. I think that the EEOC has been helpful to us in this, employers in this regard. And yeah, I absolutely agree. Well, if there are other questions, we are at the 3 o'clock mark. If there are other questions, please feel free to enter them at events@mcdonaldhopkins.com. Thank you for joining us today. We will absolutely continue to follow COVID and non-COVID related developments and get information out to you and keep you up to date. So thank you very much.